In the state of California, we have the California Labor Code, which is a set of laws that protects employees from wage and hour issues. One administrative agency we have in the state of California is the DLSE, the Division of Labor Standards Enforcement, or the Labor Commissioner, or some people call it incorrectly the Department of Labor. That's an administrative group that protects employees, and that is available for employees to go file claims and complaints against their former employers and attempt to receive that money back. Hi, my name is Adam Juratovac and I'm a California employment lawyer. And this video will talk about the Division of Labor Standards Enforcement, the DLSE, how to file a wage complaint against your employer, and the process of that wage complaint. I created this law pack that talks about the Division of Labor Standards Enforcement as an administrative agency, how to file a wage claim, how to adjudicate that wage claim, and then what you have to do to build out a case in order to win your hearing at the DLSE. Now, if you're interested in this law pack, you could find it in the link in my bio, or you can go to my website and just look up legal guides and law packs. The DLSE, or the Division of Labor Standards Enforcement, is a California administrative agency that's been tasked with enforcing California's wage and hour laws. So if you're an employee, or if you're an independent contractor who's been misclassified and is actually an employee, you could actually file a wage complaint for unpaid wages, unpaid overtime, unpaid minimum wages, missed rest breaks, missed meal break premiums, and a slew of other California wage and hour issues. Not only does the DLSE award unpaid compensation, but it also issues citations and assesses penalties to employers. Now, an increasing number of employees in the state of California are learning about the DLSE and learning how easy it is to file a wage complaint at the DLSE. That gives the employees a benefit because sometimes employers don't work with the DLSE frequently enough to understand that it's a fast-moving process, that there are certain evidentiary requirements that are not expected at the DLSE's level that you have to follow in civil court, but then there are other reasons why employers just aren't really aware of the DLSE. And because employers aren't that aware of the DLSE's processes and procedures, that puts employers and employees on a closer level. In this video, we'll talk about the DLSE, common wage claims, considerations employees should think about when filing those wage claims, and the DLSE process, which includes a conference, a settlement, a hearing, and then potentially an appeal. The wages, hours, and working conditions of employees in the state of California is protected by California law and federal law. But since California law is sometimes more protective than federal law, the DLSE will often adjudicate claims based on California law. In the state of California, California employers are governed by multiple sets of laws, including 1, the California Labor Code, and 2, the Industrial Welfare Orders. So there's about 13 to 14 different orders that govern the wage, hours, and working conditions of those many types of industries. And those are all laws that the California employers must follow in order to be in compliance. Now let's look at the DLSE. The Division of Labor Standards Enforcement is a division of the Department of Industrial Relations and is a part of the Labor Workforce Development Agency. Now sounds really complicated, so all you really need to know is that the DLSE is an administrative agency in the state of California. Now, the DLSE is headed by the Labor Commissioner, which is known as the chief of the DLSE. The DLSE offers individual relief to employees who file wage complaints with the DLSE. So once someone files a wage complaint, the DLSE then sends that complaint down to the WCA, which is the Wage Claim Adjudication Office. The local WCA office is charged with investigating the claims, setting conferences, setting hearings, and also adjudicating those claims. The DLSE also has the power to enforce penalties, including waiting time penalties and liquidated damages on the employers in the ODA, in the order, decision, or award. These are the common wage and hour violations the DLSE adjudicates. Number 1, unpaid wages. Because when your employer makes you clock out of work and still requires you to work afterwards, you should be compensated for that time. Number 2, unpaid commissions. In the state of California, commissions are part of your wages, and if you are about to complete the end of your commissions and then you're terminated because of it right before you are actually able to complete that sale, or if you already completed the sales and are terminated and your employer's not trying to pay you, the DLSE can help you out with that. Number 3, late payment or non-payment of final wages. We all know that in the state of California that your employers are required to provide you your last paycheck on the day they terminate you, which is supposed to include all of the accrued but unused vacation time that you're entitled, as well as all of your unpaid wages. So the DLSE is going to help you out with that final paycheck. 4, failure to pay minimum wage. A lot of employees aren't getting paid minimum wage because one thing that always changes every year is the minimum wage. It's either changing under the state of California's rules or each specific county may enforce their own minimum wage. I know San Francisco has a higher minimum wage than some of the other cities, as well as Santa Clara County. Number 5, failure to pay overtime. And this is one of the most common complaints I see at the DLSE or just in my practice, where you have employees who are working 12 hours a day and are either only being paid for 8 of those hours or they're being paid for 12 hours at regular rates instead of being paid overtime or double overtime for the hours that they work in a day. Number 6, meal period and rest period violations. You are entitled to an unpaid meal period and 2 paid rest periods for every 8-hour shift that you work. So, and when I'm talking about a meal period and a rest period, I'm talking about a bona fide duty-free meal period, which means you are not supposed to work during that time. And if people are requiring you to work during your meal period, then that's not a bona fide duty-free meal period, just letting you know. Number 7, accrued but unused vacation wages. In the state of California, your vacation time is worth its weight in gold because vacation time is seen as wages. It's seen as what you should be paid. So whenever you're terminated, whenever you cash out on your accrued but unused vacation time, if your employer does not pay it, then it is seen as your employer not paying you the wages that you're entitled to. And as we know, in the state of California, wages are worth their weight in gold, so the DLSE can help you out with that. Number 8, paid sick leave violations. The DLSE can adjudicate your Families First Coronavirus Response Act sick leave claims. If your employer doesn't want to pay you for that 80 hours that you took within the 2020 timeframe, then you could file a wage complaint with the DLSE and then they could adjudicate that claim for you. Number 9, unpaid split shift premiums. And if you're working a split shift, you know what I'm talking about. Number 10, unpaid reporting time pay. In the state of California, if your employer requires you to go to work and then they send you home immediately from that shift, then you're still entitled to show up time pay. Number 11, illegal paycheck deductions, because your employer can't just take all the money out of your check willy-nilly without any checks and safeguards. And number 12, unreimbursed business expenses, because if you spend any of your personal money for work purposes to complete work tasks and duties for your employer, then you need to be reimbursed for that money spent. As with any court proceeding, a statute of limitations applies to any claim that you wish to bring to the DLSE. There's a 1-year statute of limitations for an employer's failure to provide payroll records, personnel file, or for a bounce check. There's a 2-year statute of limitations for an oral contract for your employer to pay more than minimum wage. There's a 3-year statute of limitations for wage liabilities created by statute, such as violations of minimum wage, overtime, unpaid meal periods or rest periods, sick leave, illegal deductions from pay, or unpaid reimbursements. And there's a 4-year statute of limitation that applies to claims based on written employment contracts. There are typically 4 avenues for an employee who wishes to file a wage claim. Number 1 is filing a wage claim with the Division of Labor Standards Enforcement. Number 2 is filing a wage claim with the Department of Labor. Number 3 is filing a civil suit in Superior Court. And number 4, going through arbitration if there is a valid arbitration agreement. With wage and hour claims, employees do not need to exhaust their administrative remedies prior to seeking civil court action, right? Which means you could file a lawsuit in Superior Court without first going to the Division of Labor Standards Enforcement. This is different than harassment suits in the state of California, because if you want to sue a company for harassment in Superior Court, you first have an obligation to exhaust your administrative remedies, which includes you filing a complaint with the DFEH, or the Department of Fair Employment and Housing. With California wage and hour laws, we do not have those administrative exhaustion requirements. This is how an employee can file an individual wage claim. The first thing you need to do is open up Google, and I would Google DLSE, Division of Labor Standards Enforcement, wage hour complaint form. And the form that's going to pop up is something going to be called the initial report or claim, which is DLSE Form 1. And this is when you start needing to be thorough, because if you avoid or if you just do not include any potential claims that you might be entitled to on this initial form, number one, you always have the opportunity to amend your wage complaint, right? But if statute of limitations is an issue, then if you don't include it in your initial wage complaint, there might be a chance that your statute of limitations for those other claims that you did not put in there could run while you're waiting for your other wage claims to be adjudicated. So make sure you are very in-depth and you're very broad when you're talking about the wages that you may be owed. The other information being requested on this form is whether the employee is aware of other employees filing wage claims against the employer and the employer's total number of employees. If your employment was terminated, the hours and days you typically worked, the amount and frequency of payment depending on whether you were paid or promised a fixed amount of wages or one or more different types of hourly rates. Any supporting documentation you may have, such as pay stubs, dishonored paychecks, time records, or any written notice describing the rate of basis of your employee's pay. For example, an employment contract, or even just a piece of paper that says, I'm going to pay you this amount per hour. And it's going to ask for a calculation of owed wages and penalties, including waiting time penalties. That same form, you're still going to have the opportunity to provide your meal and rest periods that you missed, because then you should be compensated for those missed meal and rest periods. It's going to talk about unpaid commissions, it's going to talk about any retaliation claims that you have, any wrongful termination claims that you have with regard to wage and hour issues. And then it's going to ask you about your unpaid vacation wages. So make sure you fill out this form, you're as broad as possible, because remember, you also want to be as accurate as possible in the light most favorable to you, because you know the hours that you missed, you know the meal periods that you were required to miss because your employer said you had to work, you knew the wages that you should be entitled to. Now, don't give it up, right? You want to keep on fighting, and you want to keep on fighting for those wages because you worked for that wage. It's not the other way around. Your employer hired you in order to work for certain types of duties, and then they offered in exchange to pay you for that work. Now, don't do your employers a favor and just start giving up away the rights that you are already entitled to. Fight for your rights. And even if you lose, you at least fought for your rights, because that's what you know you're entitled to. And after you fill out that initial form, after you fill out that complaint, then you file it with the DLSE. After your claim is filed, the DLSE has 30 days to choose whether they want to drop your claim, adjudicate it, or investigate it. However, if the DLSE does not let you know within 30 days that your claim has been denied, then it just passes go. That means they cannot deny it anymore. So if you ever receive a denial of a wage claim more than 30 days after you filed it, you could appeal that because it should be processed. It shouldn't be denied. Pro tip. And your wage claim, just letting you know, it can be amended at any point in time all the way up until your hearing. So just because it's not 100% perfect by the time that you file it, doesn't mean it's not going to be made perfect by the time that you go to that hearing or that mini trial. And I'm going to talk about that a little bit later. When the DLSE chooses to adjudicate a wage claim within their process, they are also going to process that wage claim and then figure out what they want to do next. Now, a couple things that they can do is they could have a referral to that wage claim for a conference, which is, like a pre-trial settlement conference, where it's really what they call it, it's a claimant conference where you're meeting with the employer, the employer's attorney. It's going to be you, and if you have an attorney, it should be you and your attorney. And then the labor commissioner. And the labor commissioner is going to sit there and they're going to talk up to both sides about all of the claims that are being alleged on both sides. And then they're going to go to the employer. Is there a potential to resolving this claim? And the employer will oftentimes say no, but sometimes they'll say yes. And then that's when the deputy labor commissioner can start going back and forth to seeing if they could potentially resolve the situation right there. Oftentimes it does not get resolved at the settlement conference. And then the adjudicated claim will go and be set to a hearing. But before we get to that claimant conference, there are other things that the labor commissioner can do. For example, the labor commissioner can investigate the claim by having a phone conference with the employee and then just talking about the employment, learning a little bit more about the employment situation and the working conditions. And then the Deputy Labor Commissioner will sometimes amend the employee's complaint to more accurately reflect all of the issues that occurred during the employment, just based on that interview. So the Deputy Labor Commissioners are actually very effective when it comes into interviewing certain employees and also updating and amending their complaints for them. So after the Deputy Labor Commissioner interviews the employee, updates the claim, updates the complaint, they might send a notice for a claim in conference. So after the Deputy Labor Commissioner calls the employee and amends the complaint, they're going to update the complaint for you. Then they're going to send out a notice of claim in conference. And they're going to talk about if it's true or not. And then they're going to bounce out between each party and say, you know, is there a potential of resolving this claim, yes or no? And then the person will say yes. If the employer and the employee do not strike a deal at the claim in conference, then there will be a hearing that will be set. The DLSE will submit a notice of hearing to all parties involved in this situation. Now, this notice of hearing is sometimes called a Berman hearing, and the Labor Commissioner will send out notices to all the parties involved, often via certified mail, providing them of the instructions of what to expect during this hearing, what they can provide at this hearing, and also different evidentiary packets they can prepare for the meeting. Now, one little known fact is that you can actually issue subpoenas at the DLSE. So you can ask and request the DLSE to disperse subpoenas for you for certain individuals who you think will be necessary to question and to interview or to cross-examine during that hearing, during your mini trial. Now, when you're in the hearing, I always consider this as a mini trial because it's game day. You gotta be on. There's an administrator, an adjudicator, a labor commissioner who's been in the room waiting for you, who's gonna be adjudicating the claim. There's gonna be an opposing party, which is gonna be the other guys, right? The bad guys, and they're probably gonna bring their lawyer. And then it's gonna be you, and hopefully you brought a lawyer too, because if you're at this point, if you're at a hearing, this is a serious situation. Now, after you cross-examine the other side, you might have another break, and then the labor commissioner will allow room for either party to provide closing statements. Now, you could do your closing statement orally, or you could provide a written statement to the DLSE within a short period of time after the hearing. Now, it's up to you. I like oral closings, but in certain situations that are really fact-intensive and are really law-intensive, I like preparing a written response, a written closing, just to make sure that all of my points are made clearly and concisely. So once you receive your notice of hearing, read that packet very closely because you are able to provide evidence to support your claim. Now, you need to supply that evidence to the Deputy Labor Commissioner, I believe 1 to 2 weeks prior to your hearing. And if I were to make a recommendation on this, I would send them a hard copy as well as a digital copy, because sometimes the DLSE's computers aren't able to open very large attachments. And when I say very large attachments, I've seen situations where individuals prepared 200 to 500 pages of evidence against their employers for wages that they're owed, and the DLSE was unable to open up that folder, unable to open up that attachment the day of the hearing. So instead, that employee just had to go throughout the hearing without the 200 pages of evidence that he wanted to bring, but the employer submitted over 900 pages of evidence, but actually shipped it to the DLSE so they were able to review it and use it during the hearing. So read the packet closely and make sure that you create an evidentiary packet, and make sure with that evidentiary packet, you number the pages and you create a table of contents. So you want to make the labor commissioner's job as easy as possible when you get to the hearing, because once you get to the hearing, that's like a mini trial. You better be ready to roll. The deputy labor commissioner, the hearing officer, will decide who shares what information and when in this hearing. Think about this as a little mini trial. So I'm going to go over the order of operations of what a hearing officer may schedule that day to look like, and because this will allow you a little bit better insight into what to expect. So the first thing that hearing officer is going to do is explain the issues and the meanings of terms not understood by the parties. So what that means is they're going to go through the complaint and list every single allegation that you have based on that complaint, and explain anything that either party does not understand. The second step is they're going to assist the parties in the cross-examination of the opposing party and witnesses, which means a lot of people don't understand this. When you're in a hearing and the other side brings witnesses or the other side is testifying, you or your attorney has the opportunity to cross-examine that witness. So if you see that they're lying, you have the opportunity to ask them questions and try to catch them in more lies, and then that will decrease their credibility in the eyes of the labor commissioner. Number 3, the labor commissioner will question the parties and the witnesses to obtain necessary information. Part of the labor commissioner's duties is to be a fact finder in this situation, and they're going to try to find the truth based on all of the information that they have and all the information that's accessible to them. The labor commissioner will also accept and consider testimony and documents offered by the parties and witnesses. The labor commissioners also can determine which witnesses get to testify and which witnesses do not get to testify. So you're going to have the labor commissioner that is first going to ask for opening statements. So they're going to ask the plaintiff to please tell me a little bit about your work life, tell me about your employment. And then the labor commissioner is going to start direct examining that plaintiff, that employee, about all of the wages that they are entitled to, all the hours that they worked, and other working conditions, right? Now, after that occurs, after the labor commissioner asks the employee a lot of the questions that they have in line, that's when the employee's attorney can also ask that employee questions, helping and solidifying and also just like reinforcing what really occurred at that work and the hours that are owed, the wages that are owed, the accrued but unused vacation time, etc. Now, one thing where people always get freaked out and tripped out on is that employee, after your attorney asks you questions, what people don't understand and people don't realize is the other attorney, the employer's attorney, has the opportunity to cross-examine you. So when this is happening, your lawyer better get you prepped for this. But the other side's employer is going to try to poke holes in all of your stories. The other side's lawyer is going to try to poke holes in all your stories. The lawyer is going to try to make you sound less credible than you actually are. But don't worry, because then you're going to have a lunch break. And then after that lunch break, the deputy labor commissioner is going to do the exact same thing to the other side. They're going to ask the defendants, they're going to ask the employees to start talking about the working condition, how you were paid, and then all these other questions about your employment. And then their lawyer, the employer's lawyer, will be able to direct examine that employer. But your attorney, or you, if you're not represented by any counsel, you are able to cross-examine the employer and any witnesses they bring. And this is a little known fact, right? Sorry, I had to relax there and I had to talk back because now we're just, we're talking about wage and hour law and adjudications and winning hearings. So when you're talking about winning hearings, you have to have a little bit of confidence to you because it is an adversarial, combative event, right? Because just like that opposing party's attorney was cross-examining you and trying to decrease your credibility, you have the opportunity to do the same thing to them. So make sure before you enter that hearing, and then you prepare a list of questions that you want to cross-examine the other side on. Lists of questions that, if you know that they're going to answer, will help your case. You need to prepare for this hearing. And that's the hearing. And within 15 days of your hearing, the DLSE, the Deputy Labor Commissioner, should render an ODA, or an order, decision, or award. Now, this order, decision, or award will either be granting or denying that employee relief from the DLSE's claim adjudication processes. But regardless, that ODA will include a summary of the hearing, the reasons for the decision, and the amount awarded, if any, by the hearing officer. That notice will also include your appeal rights, which you need to read very, very closely, because at the DLSE, if you disagree with the ODA, you have the opportunity to appeal that in Superior Court, but you have to do so within 10 days. The state of California provides this administrative process for employees to adjudicate and file claims for their unpaid wages because wages are worth their weight in gold. And anytime an employer does not pay an employee for wages worked, there's not only actually civil penalties for that behavior, there's actually criminal penalties sometimes associated with violations of the labor code. So we take our wages seriously in California. And if you've been wronged, if your employer owes you back wages, if your employer owes you unpaid overtime, I advise you to talk to an attorney. And one opportunity that attorney may provide you, if the case isn't one that they're willing to take, is the opportunity to show you how to file a wage complaint with the Division of Labor Standards Enforcement, where millions of Californians file their own complaints against their employers all the time. The DLSE is one of the most efficient California agencies we have. And in pre-COVID time, you'd be able to just walk into a DLSE agency and ask for help and have that person assist you while you file a wage complaint. Now when everything is moving more online, the DLSE has tried to streamline their online complaint processes. And because of that, more employees are being helped. So I hope this video was helpful in discussing the DLSE wage complaint process, the hearing process, as well as the settlement conference. And I hope this video encourages you to assert your rights and make sure that you stick up for yourself whenever you're being taken advantage of in the workplace. My name is Adam Juratovac, and I'm a California employment lawyer, and my goal is to share videos that explain legal processes in easily understood ways. If this video helped you understand the Division of Labor Standards Enforcement and the processes with filing a wage complaint a little bit more clearly, please feel free to like, comment, and subscribe to my channel. And if you feel like this video will be helpful to any of your friends, please feel free to share. So thank you for tuning into this one, and I'll see you at the next hearing.